Alrighty, hello. My name is Walisha Wilson, and I'm the founder of NewLife-Second Chance Outreach Incorporated, a Georgia nonprofit that I started after my release from prison in 2012 to connect justice-involved Georgians to resources that were actually open and welcoming to people with records. Our mission is to end mass incarceration by equipping, empowering, and restoring socially, economically, and socially disadvantaged Georgians who are impacted by an arrest, conviction, or incarceration by serving as a resource hub where we only share criminal record friendly resources, events, and partner with those who work to support those who are impacted by an arrest or criminal conviction. So before we introduce you to our guest presenter, here are a few announcements. Um, our July 19th networking expo that we had for formerly incarcerated business owner has been canceled, but we will reschedule it for the fall. Also, coming up on that same day, July 19th, Georgia Justice Project and Fair Count will be hosting Pathways Over Probation and the Road to Civic Engagement through Rights Restoration. And that'll be at July 19th at 1 p.m. on Zoom, where they will talk to you about the difference between probation and parole, talk to you about criteria that makes you eligible for having your probation terminated early. There was a law that passed a couple of years ago that if you've been on probation for at least 3 years, you can request to have your probation terminated early. Talk about practical steps on how you can pursue early termination, get to know about your rights on while you're on probation and other best practices, and also about getting your vote, how to become more engaged civically with your voting rights. And so we'll drop that information in the chat so that you can have that and register for that as well. And you would like to attend the event in person, there will be a watch party happening that same day, and light bites will be served. If you're interested, you can email us, and we'll connect you to the folks at Faircount. Um, Also, if are interested in banking, they're looking for Faircount is looking for 5 to 6 people to do virtual phone banking on tomorrow night, July 15th at 6 p.m. And basically, they're wanting you to be able to call Georgia residents to let them know that, hey, you know that you can get your probation terminated early. Come join us out on the 19th, and that's pretty much it. You use a simple app that you download to your phone, your number's masked, and it calls folks like that for you. And all this information will be dropped in the chat. You don't have to worry about scattering and trying to write everything down. We will send you the recording as well as the links after this as well. On July 17th at 6 p.m., we will have a repeat session of today's session for those who couldn't make it to this 11 a.m. session. And it's going to be on the 17th at 6 p.m. It's going to be the same information, albeit, a few of the questions that may be asked of Ms. Toole, but other than that, the information is going to be the same. On July 21st at 4 p.m., we are hosting a financial literacy program that only works with people who are justice impacted regarding banking, how to build your credit, identity theft, budgeting, and practical entrepreneurship training. And then on 31st of July, we are hosting a job and resource fair at the Ellenwood Library, and it is a 100% criminal record friendly job fair. So that means everybody in the room, including all employers and all resource providers, are folks who have opportunities for people who are impacted by a criminal record. And all again, this information will be dropped in the chat. So today, we are joined by Deputy District Attorney Ramona Toole from the Office of Fulton County District Attorney's Diversions, Records, and Record Restriction Unit. Ms. Toole is an experienced Deputy District Attorney with over 20 years of practicing law in Superior Court. She's skilled in legal research, trial preparation, and customer service. So thank you so much for joining us, Ms. Toole. And of course, I imagine there's an abundance of more. If you would like to tell us, please tell us, because if you're like me, you have to truncate your bio super short. So I just want to tell you thank you so much for joining us and giving everybody the information that they're needing about getting information about how to get their record restricted or to get a pardon or answer their questions around the charges that they may have coming out of Fulton County. So from this point, I'm going to go ahead and add you as co-host if you need to share your screen, and you can go ahead and go on, Missy.
All right. Thank you so much for having me. Um, I work in the district attorney's office. I've been doing record restriction now full time since 2021. But honestly, I'm just a signature on the page. The person who makes it happen is my record restriction coordinator, Mr. Andre Moore, and he's actually on the call today as well. He's the one that gets the applications and reviews it, and then he makes the determination, types up my order, and I sign. So he's the man. So if you have any questions, want to turn in an application at the end of this, you can reach me at 404-612, and that's his handsome face right there. 404-613 8977. I think I remember that correct.
And Mr. Moore can drop that in the chat. Feel free to drop any links or phone numbers in the chat, Mr. Moore.
And I am going to share my screen. All right. Okay, good. You can see that. All right. So when I started out this being a prosecutor, I made the decision in the 8th grade that my desire was to put the bad guys away. That's what I wanted to do. That had a lot to do with some of the things that we experienced in our home as children at the hands of my father. And so I went all through 8th grade and high school and college and undergrad and my master's and in law school with that in mind. When I started working for Madam D.A. Willis, she's the elected official here in Fulton County. I came here, he was like, I want you to look at restricting records. And so I started putting myself out there. I started meeting people, I started hearing their stories, and it softened my heart tremendously. And so now, along with Mr. Moore, I am full in support of second chances. I have met people whose lives were devastated by an arrest that never turned into anything, or by a conviction that maybe there's a chance that it can be restricted. And so it changed who I am, who I became. And so that's one of the things that let me stop so I can see what I'm sharing at the same time. And so it's one of the things that I became passionate about. All right, now let me try to share it again.
Now you had shared one screen. It was a green sort of screen. We did see it.
Oh, okay, okay. All right. All right, there we go. All right. So, and so it changed my life. And so I'm very honored and by Madam DA having this unit, creating this unit where we are addressing specifically people who are interested in having their record restricted. Some of the effects that I have seen, people couldn't get jobs, people couldn't get housing. I'm actually working with a young man that was actually accepted to FAMU, and he had an open criminal case, and his money, his FAFSA money got frozen because of an open criminal case. And so he can't go to school because he needs the money. I actually had an older gentleman come in my office. He had a open arrest pending since 1971.
Hmm.
I asked him, it's 1971, why are you here? And he told me he could not get into a senior citizen living facility
Mm-hmm.
because he had an open felony arrest from 1971. And so hearing these stories, it made me start diving deep into record restriction, who's eligible, how to get it done, and what does that mean. And so I'm grateful for the MDA for giving us this opportunity to do just that. Now, so I want to start by just explaining some things. A lot of times people come to us and they say to us, we want to get our record expunged. We're not looking for a record restriction. We want to get it expunged. And so we have to explain that in Georgia, we've never been a true expungement state. We are a record restricting state. Now, when you say expungement, you're thinking about taking the white out and whitening it out, or taking that eraser and erasing it off of your criminal history. And Georgia has never done that. That's never been what Georgia has done. Georgia will restrict it from viewing from people outside of the criminal justice family. So, for instance, if somebody is approved to have their record restricted, then I will always see it as a prosecutor. Law enforcement officers will always see it. The federal government will always see it. If you're applying for a job that involves children, the elderly and people with mental health issues, they see it. But if you were to go to Walmart or Apple or the young man who's trying to get into FAMU, once it's restricted, they won't see it. And so that's why in Georgia we call it record restriction. We've been calling it that since 2012, but people still hear expungement. Now there are some states in the United States that do true expungement. Unfortunately, Georgia is not one of them. And the statute, I know people always want to know, well, what's the law to that? You can Google OCGA 35337 and it will explain it so that you can understand it. All right, so also I want to talk about when we talk about record restriction, we talk about two things. It's really restriction and sealing, but normally when we talk, we just say record restriction. But I wanted to let you know that there's a two-step process. You only fill out one application. We'll talk about that at the end. But when we talk about restrictions, we're talking about your criminal history, the GCIC, and that's what GCIC is, your criminal history, and that's being maintained and protected by GBI. And so we block that from viewing anybody not in the criminal justice family. And so that's step one. But the other step that people don't realize that's very, very much important is the sealing part. If you go right now to the 136 building, Odyssey, you can put in anybody's name who's been arrested. You can pull up the police report. You can see anything associated with that because it's open to the public. And what we have is a lot of people. I don't know if y'all saw those bookingphotos.com people. They go in, they get that information, they get that booking photo, they put it on a separate site. And so you could get your case restricted, but if that information is still not sealed, it's still open to the public. So when we talk about sealing, we're talking about sealing that court record so that when somebody goes in, let's say they have the case number, it's going to say not it'll say confidential or it'll say no record found. So when we seal, we're sealing the booking photo, we're sealing the fingerprint card, we're sealing the incident report, anything associated with that case. Now, we just don't call it restriction and sealing. We just lazily call it just record restriction. But you want to make sure that that second step is done. Now, what I will say is for those bookingphoto.com people, we don't have any control over that. So when we say we're going to seal your booking photo, that's on the sheriff's website. But I've been told by two defense attorneys that if you go to take your order and take it to those websites, that they should remove it. I've never seen that happen, but I don't actually go that process. But will seal your booking photo on the sheriff's website. Now, I have a intern, and she was like, "Well, what can be sealed? What can be restricted?" And I said, "You know what? That's a good question." So we're gonna give you some examples of cases that can be restricted and some cases that cannot. Okay. So the easiest ones are the cases that can be restricted under the law. There was a period of time, and it doesn't happen as much now as it used to happen back in the day, where someone was arrested. They bonded out before the case went to first appearance, and that's your first opportunity to see a judge after being arrested. Some people, the officer will put a bond amount on the ticket, or they put a bond amount on the warrant, and they'll just bond out before first appearance. Sometimes those cases, because they bonded out before first appearance, sometimes those cases do not get to us. And so we have hundreds and hundreds and hundreds of thousands of open cases from the 70s, 80s, 90s, and the 2000s, unfortunately, where people were arrested, they bonded out in a day or they bonded out in a few hours, and those cases never came to whichever prosecutor it should have came to. And so in those cases, if the statute of limitation has passed, those cases are eligible to be restricted. Now, the statute of limitation is it sounds simple, it's not as complicated, but I'm here to tell you that typically most felonies, the statute of limitation is 4 years, except for murder. There's no statute of limitation for murder. But for most felony charges, the statute of limitation is 4 years. So if you have a case, and I saw one just yesterday where she was arrested in 1997. It never came to our office. It was, I think, a forgery or something, forgery or theft. That case is eligible to be restricted because we never got it and the statute of limitation has ran. The law is never going to punish you because the prosecutor never got the paperwork. You get the benefit. Two, cases we dismiss prior to an indictment. So we do get cases in, and I remember being a baby lawyer and I was working in the complaint room, which is now called case intake. And we have a case where an officer made an arrest, and then once we get it, we review it. And we'll say, oh, the stop is bad, the ID is bad, the search is bad. For whatever reason, we will make the decision we're not going to indict this case. We're not going to go forward with the case. And so we will not present it to the grand jury, or we will decline to prosecute, or we will dismiss for want of prosecution. And in those cases, those people are eligible to get their record restricted. Grand jury return two no bills, for those who are up in age and watch Law and Order. Typically, you can indict a pencil and you can indict a ham sandwich because it's easy. But sometimes the grand jury say no. So you present the officer in front of 16 to 32 people. He comes in, he says, I was called out to this scene, and Mary said John shot her. It happened in Fulton County. And sometimes the grand jury said, oh, that's enough to go to the indictment, which means it goes to the next step. Sometimes they say, oh, that's not enough. And then we present it to another grand jury, and that grand jury says it's not enough. At that point in time, we can't go forward with that case. And so if you have a case that, and most lay people outside the district attorney's office won't know that, but if the case was presented to the grand jury twice and both times there was a no bill, that case is eligible for record restriction. Now, here's other opportunities for cases to be restricted. Let's say we did indict your case and we decided for whatever reason, we're going to dismiss all the charges. That's eligible for record restriction. We do offer in our office, we have a diversion program, a PTI program, which is a pretrial intervention program. These are programs where, similar to our diversion program, and our diversion program is in-house. It was one of Madam DA's campaign promise on her first run, is to create a program where you're low risk, low need. You come into our program, you take classes that we teach ourselves. You do community service. You reimburse victims if there's a reimbursement. You do an essay. You do a sometimes people are required to do family violence classes. Sometimes you're required to do therapy. It's a built-in program that's absolutely free to the individual. And if you take that program or a similar program and you have completed it, then your case is eligible to be restricted. Sometimes you may decide to do first offender, or you may decide to do conditional discharge. And both of those are probation. You do first offender probation and you get an order of discharge. And the way first offender probation works, you only get it one time. And you take a plea to either you take it for a felony charge or a misdemeanor charge, you only get to do it one time. And if you successfully complete it, you get an order of discharge, and then you can tell future employees you've never been convicted of this charge, and it'll be restricted. Same thing with the conditional discharge or the drug first offender, which is under the OCGA 1613-2. Those are two things you can only use once. So if you use that first offender on a misdemeanor, you can never use it again. Conditional discharge, it has to be a drug-related charge. So if it's a theft, you committed this theft because you have issues with drugs, and you can only use that once. But once you complete them, then you can tell future employees you were never convicted of those crimes, because even when you take a plea pursuant to the First Offender Act, when you walk out of that courtroom, you're not a convicted felon. You are a first offender probationer. So if you do everything you're supposed to do, then you get this benefit. Now, I always tell people when I take pleas pursuant to the first offender, you want to take advantage of this, because if you go all the way through first offender, let's say you pled to burglary and it's 20 years, that's the maximum sentence on burglary. And under the first offender, you get 10 years on probation. You get to the next to the last day on probation and you violate that probation, they can bring you back, they can take away that first offender status, and they can resentence you up to 20 years minus any years you've already served. So there's a huge weight on your shoulder with first offender, but the beauty of it is that if you do everything you're supposed to do, you get that order of discharge, you can tell future employees you've never been convicted of a crime, and you get the benefit of getting it restricted and sealed. And then lastly, if you were acquitted, you went to trial and you were acquitted of all those charges, meaning you were found not guilty, you're eligible to get that case restricted. Now there's some other examples of when you can get a case restricted. These are the popular ones. So I tell people, when in doubt, reach out to Mr. Moore, reach out to myself when in doubt, and let us tell you no. Don't assume no. Let us tell you no. And I see questions in the chat. I don't think they apply to me.
One question I think, and you were speaking about, okay, Mr. Moore answered about the diversion program, as well as what we're talking about with the first offender.
Mhm.
Um, and just for going forward, we try to we are really big on trying to use humanizing and person-centered language. And I know that takes a lot of time for folks to get used to. So we really, really ask that we not use terms like felon, criminal, prisoner, inmate, convict, or person, as opposed to a person with a felony. But I know it takes some used to, because we all say, "Oh, I'm a felon, I'm a felon." Um, but sometimes it can be triggering for folks, and we want folks to also see, like you said. I think I am a firm believer that laws are made to impact folks who they're going to. So when you make laws for felons and criminals and savages, those are the kind of laws. But when you make laws different for people, they're a little bit more person centered. So, but I just wanted to mention that because you did say felon a couple of times. But yeah, the question was about the diversion program. I only found out last week that you have to actually apply for
Yeah.
a public defender. So I didn't know you had to do this kind of stuff. So the question was, is that diversion program available? Do you have to apply for that before you've been sentenced, or can you apply for it after you've been sentenced?
So with the diversion program, I
Oh,
as soon as you get arrested, you can contact my office. You can contact me. I also run the diversion program as well. So I do have a director. I have mothers calling me. I have defendants call. I have people who are incarcerated call me from jail.
mhm.
It is a pre-sentencing program. So if you've already pled, it's not a program that's eligible for you, but it is a pre-sentencing program. So as soon as you get arrested, I've actually had officers who have arrested people and they will say, "Hey, I just arrested somebody, but I think they'll be eligible for your program." Um,
Mm.
we have had big mamas. I have been stopped at Walmart. Somebody stopped me at the Walmart in DeKalb of all places to say, "Hey, I have a son that's currently being held in Rice Street, and I heard about your program. I saw your picture. I knew that was you. Can I talk to you about it?" So anybody that's interested, particularly in our program, you just reach out to us. And you don't have to have an attorney to reach out to us. We will talk
Okay.
to you if you are interested. And,
Okay. So
and
I
it's
just wanted to make sure, because I actually had a mother call on Thursday. Her daughter was, I guess, that ACDC that's in Fulton County, arrested, never gotten in trouble before, and went before she said she went before the judge without an attorney, and the young lady was bailed out, but has been placed on 24-hour lockdown at the house. And because I guess she pled or something, I guess you had to, I don't know how that works, but she must have pled. So she asked, is there not some type of diversion program? And I thought that's something you have to get done before she's sentenced. So I just want to make sure as well that people are clear that this is a program out there. And it's actually really good that you actually have law enforcement officers that will call and say, we want to get this. Because I mean, things happen, especially if you're around the wrong people. And people should not be punished for something for the rest of their lives. I know folks right now walking around here who had a conviction that's 40 years ago, and they're still being denied housing. They're still being denied employment. And that's not how that should be. So people really should be able to have opportunity to have second chances through programs like this. So thank you.
You should. And the thing when I talk about the first offender, I always stress when I take a first offender plea that when you walk out of here, you are not a convicted felon. Don't have that
Mm-hmm.
on you. You are a first offender probationer. That's who you
Mm-hmm.
are. And if you do everything you're supposed to do, then you will never have that title of a convicted felon. Even if you take it under the drug first offender, under the drug first offender or conditional discharge under OCGA 1613-2, when you walk out of that courtroom, you're not a convicted felon. You're not. You are a conditional discharge probationer. And
Well,
so
it would be really great if the employers and the housing providers know that. Because me, myself, as a person who was convicted, who was not convicted of having a felony, but was placed under the first offender, and I say that only because that's the name of the law.
mhm.
You people are technically were being on first offender for 10, 15, 20 years, and that stuff is still showing up on housing applications, still showing up on looking for jobs and employers were still seeing it. So it wasn't anything that was good and tangible, like, hey, it's not really should be showing up on your record. And I think with some of the great work that GJP has been doing to make sure that that's something that is something true, because if a person is sentenced as a first offender, it should not be on their record. And people should not be expected to go 5, 10 years with it being on there as saying that you are first offender. So
so,
that it can be detrimental.
So a couple of things with that. Number one, um, if you take a plea and you take a plea pursuant to the First Offender Act, it will show on your criminal history. It should show that you pled guilty pursuant to the First Offender Act. Now, what people don't know is that it will show even while you're on the sentence, unless at the time of the plea you ask the judge to restrict it at the time of the plea. And then you either you or your attorney, if you're pro se, meaning you're doing it yourself, or you have an attorney, your attorney can ask at the time of the plea for the judge to restrict it. If that is case, if he agrees, it's restricted at the time of the plea. And that's how it goes. And then if you don't complete it, it'll be unrestricted, you'll be resentenced. Uh,
And that's what I don't get and understand though, Miss Toole, because we're the ones that's in court. We don't know no better. We didn't go to law school. So
but
all the lawyers should know that to
your
automatically request that at the
your
sentencing.
attorney should, and they don't. I have taken thousands of pleas and it's not asked. It's up for that, and I don't know why, but it's up for the attorney to inform their clients that you can ask at the time of the plea to get it restricted.
I
The
didn't
other
know
reason
that.
why some people take first offender, and I'm actually dealing with this when I get off the Zoom, is sometimes the probation. It could be a breakdown in several ways. Number one, probation never did an order of discharge. They never sent it to the clerk's office. If they don't send it to the clerk's office, that can be a problem. It won't get restricted. Two, in certain counties, probation has sent an order of discharge over to the clerk's office, and it's just filed and they don't read it to know that they need to restrict and seal it. So I have a lot of people who come to me who either don't have an order of discharge and I have to send them back to probation, or they have an order of discharge that's been there for years. It just never got restricted and sealed. And then I'll do the order to get it restricted and sealed. So, what I tell people, how we check our credit report, we check our credit report because we finna buy a car, we want a credit, we want a house, we want something. You need to be checking your criminal history just at the same time.
Mm-hmm.
And if you see something on there that is incorrect or not totally correct, then you need to contact the prosecuting office that had that case and say, hey, this isn't right. And I also want to say that unlike a credit report, your criminal history will follow you beyond death. Things on your credit report falls off in 7 years. Your criminal history, it will follow you beyond death. So we should be actively checking it every 6 months at least, or every year. You go down to your local law enforcement office with your identification. You say, hey, I want to pull my criminal history. Now, if you're an individual who has some cases restricted and sealed, you want to see what employers see, you need to ask them to run it for employment purposes. Because if you say, let me see my criminal history, you're going to see everything like I can see everything. But if you want to see what employers see, then you tell them to run it for employment history, employment purposes, and then you will see it. It's a charge. But if you're eating at McDonald's, if you go
Mm-hmm.
to the Walmart to buy junk food, you can take this money and invest in yourself and pull your history. And I think everybody should pull their history because someone could use your name. Somebody could use your date of birth, and it'll take you years to correct it, but you need to know that you need to correct it. So please run your history. The sheriff's department, your local police department. And if you want to know your Georgia history and you are not in Georgia, because you have to go to the police department, you have to go to the sheriff's department with your identification. But if you're outside of Georgia and you want to know what your Georgia history says, contact the Chamblee Police Department. That is the only police department in the state of Georgia that will let you do a request, and not come in. You can fill out the application,
Mm.
send the identification in, and they'll give you that information. Any other police department, you're going to have to be physically there for them to give you your criminal history. But if you're outside of Georgia, you want your Georgia history, contact the Chamblee Police Department. I got that straight from GBI, and I've had several people do it, and they were able to obtain it. All right, so now we get to the negative side. So these are things that cannot be restricted, unfortunately. You went to trial and you were convicted of some charges and you were acquitted of some charges. Those charges that you were found not guilty of can't be restricted because they're on an indictment that you were convicted of. My example is you have 100 charges and charge number 67 was disorderly conduct and all the other charges was murder, and you were acquitted not guilty of all the murders, but count 67, the disorderly conduct, they say, yeah, we found you guilty of that. Unfortunately, that case can't be restricted. Now this one, I always get pushback on this one, and I just have to tell you that, oh, not this one. This one, I'm sorry, I'm getting it confused. This is if you went to trial and you got found not guilty, and we were able to prove, which is very difficult to prove, because I tried one time, that you were acquitted because of jury tampering, then you're not eligible. This is the one that people always get upset about. So you were in your car and you're riding down 85 and the police pulled you over. Come to find out, was no real reason to pull you over. Um, the officer searched your car, didn't have a warrant, didn't have your consent, didn't have no probable cause to search your car, and they find 1 million pounds of cocaine in the trunk. And so they charge you with drug trafficking. And we said we're going forward with drug trafficking. You get an attorney who reads the police report and who says, wait a minute, that stop was wrong. That search was wrong. These drugs should be suppressed. And so they file a motion to suppress the drugs. And the judge says, yeah, the stop was wrong. The search was wrong. I'm going to suppress the drugs. And that's the only charge in this indictment. And the state says, well, since you suppressed the drugs, we can't go forward. We're going to dismiss this case. Now, I told you, if a case gets dismissed, the case can be restricted. This is the example of that. If your case gets dismissed as a motion in limine or a motion to suppress, and we couldn't go forward because our evidence was suppressed, unfortunately, under this statute, you can't get that case dismissed. You can't get that case restricted. And so it sits on your record. And a lot of people get upset about that because you were, like, wait a minute. I don't know the rhyme or reason. I just know that if we can't go forward with our evidence because a motion in limine or a motion to suppress was granted, you can't get that charged. You can't get that restricted. This is hardly ever happen, but no, this is not it. I keep getting myself confused. You took a car in DeKalb, and then you drove to Fulton and got arrested in Fulton for theft by receiving stolen car, and you plead in DeKalb, and so we dismiss our charge, that case cannot be restricted. Okay, so those are some examples of charges that cannot be restricted if it happens after indictment. Now, one of the good things that the legislature did back in 2021 is one of the things that they did is they have this thing called retroactive first offender. So what was happening back in the day is that people were pleading to felony charges, or people were pleading to misdemeanor charges. They were pleading to these convictions, and they weren't told at all that you had the ability to get first offender. And so it has always been out there, but they weren't told in advance, so they just pled. They took the charge for whatever reason, wrong or right. And so now we have this thing called a retroactive first offender. And so you pled in 1996 to a felony charge, and now this is holding your life up, and you haven't used first offender at all. We can now go back and give you first offender retroactively. And in the same order, we can give you first offender, give you an order of discharge, restrict and seal. The thing about retroactive first offenders, some people say, oh, I don't want to go back on probation. I don't want to do that. No, you don't go back on probation. We actually do everything in one order. We give you what you were entitled to back in 1986. Now the law has changed. So now lawyers are required to tell people prior to sentencing, like, hey, you're eligible for first offender. Do you want to take it? Now it's a requirement. But back in the day, it wasn't a requirement, and people didn't know. People didn't know to ask, and I don't know why people didn't tell them, and people didn't know to ask, so they didn't do it. So retroactive first offender is our key now. As long as you were never given that opportunity, and we look at the transcript, and you've never used it, and it is an offense where first offender is eligible for, we can go back and give it to you. Now, if you were under indictment and if you pled to certain charges, it doesn't matter that they didn't tell you about first offender. Here are some charges that you cannot get first offender on. Your serious violent felonies, which would include armed robbery, those 7 deadlies, I call them the nasty charges, those sexual offenses that I don't like to talk about, murder, if you had ag assault on a police officer and he was injured. Those are charges that if you were convicted of, you can't get first offender on it, so you can't get retroactive first offender. Any charges dealing with neglecting an elderly person, any type of, sexual exploitation of a minor. These are some of the charges that if you were convicted of or charged with, you couldn't get first offender. You can't get retroactive first offender. The one that I have to keep stressing is DUI. If you plead to something as simple as DUI, it can't be restricted. A DUI conviction cannot be restricted, and you cannot get first offender on a DUI, and you cannot get retroactive first offender on a DUI. A DUI is a conviction and it stands. So I like to make sure that people understand that. When it comes to pardons, I want to talk a little bit about a pardon, and I know we're about to run out of time, so I'm going to speed it up a little bit. Certain felony convictions can be pardoned by the governor, not by the United States president. People always ask me that question. No, you will file applications with the Pardons and Parole Board, and certain offenses can be pardoned. Now, unfortunately, in the state of Georgia, GCPD is really trying, Georgia Justice Project is really trying to change this. Unfortunately, if you apply for a pardon and the case is in fact pardoned, you have to come back to my office or go back to the prosecuting office and ask for that to be restricted and sealed. One of the things that Georgia Justice is trying to do is make it an automatic thing. If it gets pardoned, it's restricted and sealed in the same document. They haven't had any luck. So anybody who gets a pardon and it's approved, you contact the prosecuting office to get it restricted and sealed. And there's no limit on the number of times you can ask for a pardon. Now, this is what changed in 2021. It used to be all misdemeanor convictions. If you pled, you can't get it restricted. But the governor in 2021 passed the 35337J4, and you can get 2 misdemeanor convictions in a lifetime restricted. 2. Um, but your last conviction, last arrest has to have been 4 years ago. So if somebody had a misdemeanor conviction July 14th, 2022, they're not eligible until next year. So you have to look at that time frame, but you can only get 2. This is something that helps a lot of people because sometimes employers, sometimes schools will hold a misdemeanor conviction against an individual. So now you get 2. Again, DUI is not one of them. And there are other charges that don't count. Any type of domestic violence charges, as you can see here, violating a family violence order, child molestation, any of these charges, if you pled to them as a misdemeanor, you can't get them restricted. You will have to apply for a pardon. Here's some more examples of misdemeanor convictions that cannot be sealed and restricted. Public indecency, keeping a place of prostitution, pimpering, obstructing a 911 call, peeping Tom, certain theft charges, again, DUI. You're convicted of those, you're going to have to get a pardon. Now, this is something that is relatively new. It was also, I think, in 2021, 2022. It's called a survivor's first. Unfortunately, we're in a time where people are forced to do things that they don't want to do. Some people are forced to commit crimes. Some people, while being being sex trafficking, sometimes they commit crimes to alcohol crimes or drug crimes to cope with the situation that they're currently in. Well, the law has now said that if you are a victim of human trafficking, and because of that you were convicted of felonies, or you were convicted of misdemeanors, you're able to have those misdemeanors and those felony convictions restricted as long as you can show that those convictions happened while you were being trafficked. That's simple, filing an application with any prosecuting office and allow them to have an opportunity to speak with you. I think that this law is something that should have been done a long time ago. I'm glad it's in place now because sometimes you're forced to do things that you would have never done but for the fact of your situation. And you shouldn't be held accountable for those choices that you were forced to make. And now the law allows relief under the Survivors First Act, human trafficking. So we normally do record restriction events where we go out into the public. We just had one, as a matter of fact, at the CT Martin the first Saturday in June. But typically when I have people that qualify under this, I ask them to come in so that I can be respectful of their privacy and give them the time they need to talk. So make sure if you know anybody who falls under this category, they reach out to the prosecuting office. All right, can't say it enough. Can't say it enough. I put this in red because I need people to understand a DUI conviction cannot be restricted, cannot be first offender, cannot be retroactive first offender. So keep that in mind. If you have a DUI charge, it cannot get first offender. We have had cases where judges have given first offender on a DUI. It is not valid, and that will be denied not only by the prosecutor, but they'll be denied by GBI when they get that request. So please keep in mind, that's why I made it red. That's why I got the big white thing here. I want to make sure it stands out to you. Now for our office, each office is different. We have office hours here. We're at the 141 Prior Street building, suite 2085. You can come into my office Monday through Friday, 9:30 a.m. to 4 p.m. You can fill out this application. It's really simple. Or you can go online to the Georgia GBI and fill it out. Or you can go to our website. We do have a portal that you can fill it out with the website. But if you do fill out this paperwork, we ask that you complete every line from the top to the bottom. Make sure the information is correct. Make sure you print, because y'all, some people have doctors' handwritings and we can't read doctors' handwritings. So we ask that you print and then you submit it. Once the application has been done, it can take us anywhere 45 to 60 days to respond. But we ask you to be patient with us and we will get back to you. Every office does things differently. My office, it starts with Mr. Moore and then it comes to me. So, but I'm here if you have any questions. So that was a lot of information. So I don't know if anybody have any
It
questions.
was. Yes, and there was a question that was dropped. I can't remember what you were talking about, but the question was, what about 2007? So, Chandra, Miss Gay, if you want to come off, you can ask the question yourself. But it was something you must have referenced about a particular year.
Oh, okay.
Did you want to come off mute and ask it? Did you mention somewhere in your presentation where it had to do something about a certain time or a year? Because that as soon as you said something about it, she asked about it. It was about 5 minutes ago. The question was, what about 2007? I think maybe you were going over when some charges would be extra. Miss, you want to help me out, Miss Chandria? Okay. Maybe she walked away.
Oh, okay.
But yeah, if we have any other questions and if they send us, we'll make sure we drop the information in the email that you would prefer that we do have that, but the email is that record.restriction at Fulton County. That's the question. That's the one.
Yes,
Okay.
it takes you to
So
and also it also will take you to our portal if you have any questions. And we're here. One of the good things about Mr. Moore, he is on top of his emails, he's on top of his voicemails, a little bit more than me. Shouldn't say that, but he is. And so if I don't get back in touch with you, it'll be Mr. Moore. So if whatever your
okay.
question, if you think of the question later, you can call us or email us.
Okay. And we do have all the information. And again, I'll be composing the email, sending it to everybody with all the links that were dropped in the chat. And I know we talked about that. Can you tell us briefly about pardons? I know you went over it very briefly, but just the rundown. Who's eligible for a pardon? Is it 10 years, 5 years? What is it?
So I think that the if I remember correctly, it's 5 years. Like you can't have any convictions or any open cases for 5 years. The other thing that I want to make sure I stress to you because it's not a hard process. It's just tedious. You want to
Mhm.
go through your history and you want to make sure you don't have any debt dockets. Okay. Because if you have any case that has been, because they're going to look at your whole history. Okay. If you have any case that has been debt docket, they're going to send you back and you don't want to lose that place in line. So before you apply for a pardon, pull your history, make sure that you don't have any cases on there that have been dead docket. If you do have a dead docket case, and what a dead docket case is we took it off an active calendar and we kind of set it over here on this shelf in space. It is still an open case. You can have a dead docket when Moses parted the Red Sea, it's still an open case. And the Pardons and Parole Board won't deal with you, won't talk to you, won't even consider you as long as it's there. So if you look at your criminal history and you see a dead docket, a charge that was dead docket, or a case that was dead docket, contact that prosecuting office and have them take that case off the dead docket and dismiss it or null process, which is the Latin term. The
And what exactly does a dead docket mean?
It just means we took it off an active calendar for various reasons, and we
Okay.
just set it on this cloud out over here. So it's no longer on an active calendar, but it's still considered by all means an open active case. It's just not on, it's just, and it's one of those things kind of like out of sight, out of mind. We,
Mm-hmm.
we put it over there. So back when I was a baby attorney, instead of null processing a case, we would put it on the dead docket. And so there are hundreds and hundreds and hundreds of thousands of cases that are on the dead docket. Now, if a case has been on the dead docket for more than 12 months, you're eligible to get that case dismissed. Unless it's one of those cases where you had a dead docket so you can do PTI, then you would need to provide proof that you completed that PTI program. But for the most part, if your case was just placed on the dead docket and it's been more than 12 months, you're eligible to get that case non-pros. And typically, you can contact the prosecuting office and ask them to take it off the dead docket. If they won't take it off the dead docket, then you have to file a motion and go before the court. But you want that done before you get in line of the pardon. Now, also with the pardon, it is done online now. It used to be you can go down, I think it's down the street from where I am, but you can do it online. You can set up an account and it'll walk you through the process of how to do it online. Don't get frustrated. You don't need an attorney. It's just tedious. You just need to make sure you follow the instructions. So anybody can do it. Just take some time. Now, if you want some help, contact the Georgia Justice Project. They will help you through the process. But if you want to take a look at it yourself, you can do it yourself. And then once it's pardoned, it will say pardon on your criminal history. And so you're supposed to get your rights restored. So that's one of the great things about a pardon is getting those rights restored. And that's great and wonderful. Your civil rights, you get those back restored, but you want that restricted and sealed too. That's
Yeah.
important too, because
So that's a whole different step.
right, then you have to come back to that prosecuting office. So let's say it was one of our cases, Fulton County Superior Court case, and you go to the pardon parole board and they pardon it. They're going to send that document back to the clerk's office, but it's not an automatic thing, unfortunately, right now. So you have to come back to me and say, hey, it's been pardoned. I want to get it restricted and sealed. And then we'll restrict and seal. So then you get your rights restored and you get the case restricted and sealed. And it puts you back in the position you were in before any of this had ever happened. So hopefully that
Okay.
answers.
And so what's the likelihood? I know I've asked this and I used to harp about this a lot as well. To me, pardons were a bunch of crap. If you're gonna give me a letter and says, show this to the person, because once people can't unsee what they have seen. And to me, I felt like it was a bunch of crap. It's just on paper, it's not anything permanent. So Georgia's not one of them states that says you got a pardon, that means we're gonna wipe your record clean. So you technically have to say, hey, here's a certificate that say you got a pardon. Just show this to them, and they're looking like, pardon, 21 charges. It's like that. So what you're saying is, even though you have this, you take their certificate, and then you now have to go before a judge to request that your record be sealed.
Mm-hmm. And I would
And
start
so,
with the
what's the
prosecutor.
likelihood of you getting that? Once you got your pardon, is that usually something the judge will go ahead and say, "Oh, well, we've already given you a pardon." Is it easier to get it sealed once the judge has somebody's already given you a pardon?
So I have been in record restriction since 21, and every single case that has come through my desk where it was pardoned, I have agreed to the restriction and seal. So we hadn't had to go to the judge to ask because
Oh, okay.
the statute allows pardoned cases to be restricted and sealed. So we hadn't had, I haven't had it, but that's why I said start with the prosecutor because to go to the judge, you got to file a motion, you got to get on his calendar. Start with the prosecutor because you may have a prosecutor that says, "Oh, you got a pardon. Pardons are restrictable. I'm going to just restrict it based on that pardon." And then that way you don't have to worry about filing a motion, get on the judge's calendar and having a whole hearing. So
Okay.
Mr. Moore and I, when we see pardon, we just type it right on up and send the order to the judge for the judge to sign.
Okay.
Yeah. Because to me,
Thank you so
that's the
much.
purpose. You got a pardon.
Yeah.
That was the purpose of getting a pardon. Now,
Okay.
I will say sometimes what they will do is they will pardon you, and then sometimes they will just restore your rights without a pardon. You want to make sure that you are applying for a pardon and not just a restoration of civil rights, because those are two different things. And I have people come to me that says, I got my rights restored, so it must be pardon. I'm like, no, those are two different things.
Okay.
If you get a pardon, your rights are restored, but you can't just get your rights restored without the pardon. You need the pardon in order to get the case restricted and sealed.
Okay. So I think I had spoke with you about this is a question that we always get, gun rights. And I tell people I don't care what folks have done or whatever crime they've done, everybody deserves the right to protect themselves and their families. So that is a question we always get, that when you get, how can I get my gun rights? So when you get pardoned, and is that a separate rights? I know when you get pardoned, you get your civil and your voting rights and stuff back. but is gun rights included in that, or is that something completely separate?
And that one I can't answer.
Okay.
Yeah.
Okay.
I get that question all the time. You think I would get it, but I don't know.
Okay.
That would be a decision of the probate court. So
So
you
that's not automatically more than likely.
you would
Okay.
have to apply, and I don't know how the probate court reads it. But the
Okay.
probate court judge is the one, um, yes, and also you can contact ATF as well to see your eligibility.
Okay. And that's definitely going to have to be a different webinar then, because we definitely get a lot of calls about gun rights.
That'd be the main
Some
thing.
folks may have gotten pardons, and then they say, well, they told me I got my rights back because I got a pardon, but my gun rights weren't restored. So I didn't
Mhm.
know if that was a whole separate process or somebody made a mistake. So I think that's something too. Okay. Well,
Yeah.
thank you. This has been very helpful. Is there anybody on the call that has any questions before we jump off? This has been a great, great 1 hour lunch. Um, very informative. So I hope you all found some very interesting information and got your questions answered. And for some reason you had questions and could not remember, or you thought about it, we will have this session again on this Thursday coming up at 6 p.m. So you can jump back on that call, because you never know. She's going to go over the same thing, but maybe the examples will be something different, or maybe somebody in the chat will ask a different question that sort of will help you out as well. So please feel free to join us again for this Thursday, same place where you went and registered. It's a different form now. So this form was different than the one for the 17th. But go back to the same website and register for that as well. If you do have a record, please join us on the 31st in Ellenwood for our criminal record friendly job and resource fair. We have about 30 already folks who signed up, and 8 of them are employers. I'm talking about from the Georgia Department of Transportation, from DOT to several other companies who will hire people with felony records. So if you have a felony, this is the place to be. We do not share any resources that are not open to people with criminal records. So we not say we don't partner with folks, because everybody can use food and clothes. But if you are an employer and you're calling us saying, please share our jobs, if you do not hire people with criminal records, we do not share your jobs. So this is the place you want to be if you're looking for employment or a better job, if you're in the metro Atlanta area, and some of the jobs are statewide. So we'll make sure we send you, everybody who has registered will receive the email with all the checks. So again, I want to thank you so much, Ms. Toole, and thank you, Mr. Moore, for being so helpful in the chat as well. I'm really grateful, appreciate it. And thank you. This was very informative. I actually learned something. I usually tend to be a really self-absorbed, and I learned a lot of stuff. If you would like, if you have slides that you want to show out, send them to me. If not, we do have the thing, but if you have them and you just want folks to have access to them, if you can send them to me, that helps. But if not, they will be actually sending a link to the YouTube as well. Thank you all so much, and hopefully we'll see you both again on this Thursday, the 17th at 6 p.m.
Definitely.
All
Thank
right.
you for tuning
Thank
in.
y'all. Have a great one.